Good morning, Mr. Nqumse.
Good morning, Acting Chief Justice.
How are you this morning?
Well, Chief Justice, I'm well as far as I can be.
Okay. Okay. Well, welcome to this interview session of the Commission, and thank you for having availed yourself for consideration for appointment as a judge of the High Court of the Eastern Cape.
Thank you, Jay.
I see that you hold the degree of BProc and then an advanced diploma in labor law and a postgraduate diploma in criminal justice. Is that what it is?
Yes, ACJ.
Yes, and you obtained your BProc from the University of Fort Hare in 1991.
Correct, ACJ.
And your advanced diploma in labor law from the University of Johannesburg in 1998.
Correct, ACJ.
And the third diploma from the Nelson Mandela Metropolitan University in 2013.
Correct, ACJ.
Yes. And you started your career with the Department of Social Welfare as an administrative clerk in 1986, is that right?
Correct, ACJ.
And later on you went to the Department of Justice and as a public prosecutor.
Correct, ACJ.
And in 1994, you became a magistrate, is that right?
Correct, ACJ.
And that went up to, you were in, is it Paddy?
Yes, yes, ACJ.
And then later you were in, I can't see, Komani, is that right?
Yes, ACJ.
As a magistrate. And then as a senior magistrate and a district head in 2000 to present, is that right?
Correct, ACJ.
Yes. As a magistrate at different levels thereof, have you had exposure to adjudicating civil cases?
Correct, ACJ.
How much exposure have you had? Can you give us more information?
As a magistrate, ACJ?
Yes, as a magistrate.
As soon as I got to Komani, which was in 1998,
yes,
I was thrown into the deep end to do a civil matter, which was complicated in nature at the time. And I think this was just testing my mettle. And that matter, incidentally, was a matter in Afrikaans, or it involved Afrikaners, which I had to handle. And after having dealt with that matter, which went even to the appeal in the Grahamstown High Court, and it was upheld, I developed love for civil, and thereafter I never stopped to adjudicate in civil, and it became my forte in that I spent most of the time in the civil court, much as I also dealt with criminal work.
So you say from 1998 you have been adjudicating civil cases.
Correct, ACJ.
And did that change when you became district head, or did it not change?
It didn't change, ACJ. In fact, when I became the head, that's when the volume of civil work for me increased, because in most instances in our courts, in the lower courts, civil becomes the domain of the district head. So instead, it increased for me.
Yes. So the picture you give us is that for more than 20 years, as a magistrate, different levels, you have been adjudicating civil cases. Is that correct?
Yes, ACJ, I have been, though it depends how busy the court is in civil litigation, but I have been adjudicating civil work right through my career in the district court. But yes.
Yes, go ahead.
Particularly from 1998 and 2000.
And have you got an estimate for us of how many judgments you have written over that period? 300, 500, or more than whatever the number is?
I would prefer to be modest, ACJ, and say probably 300. I didn't count, and I'm sorry that I didn't do that.
That's fine, yeah.
But I would rather choose to be modest and say not more than 300.
You say not more, do you mean not less than? Or?
Not less than 300.
Yes,
Yes,
okay.
yes, ACJ.
So there's a chance that they could be 400 and so on, but you want to stay with a number that you feel more comfortable with.
Correct, because they could be more in that I was involved in civil trials as well as the motion court. So there would be from time to time matters that arise at that stage.
Yes. Now, in motion court, in the magistrate's court, how heavy would that motion court be most of the time?
We held our motion court, which is still the practice now, ACJ, on Thursdays.
Yeah.
Especially before the National Credit Act, one would get plus or minus 30 to 40 files per motion court day.
Yeah, okay.
Yes, yes.
And what percentage of that would be opposed motion matters? More or less. Would it be about half of those or less?
Probably 30% to 35% would be then opposed matters, BCJ. Yes.
Okay.
Yes.
And in terms of what branches of law the motion court and civil work covered, are you able to give some indication?
Well, our civil work would cover a couple of areas, but mainly delict, damages arising from unlawful arrest and detention, defamation matters. Well, of course, in the motion court, various kind of applications would surface, exceptions, and of course, the bulk of the matters would be those that are related to debtors. Yes.
Okay. Judge President.
Thank you, ACJ. You've acted in the High Court especially during my JP-ship. And you've also acted in Gauteng for a full term.
Correct, JP.
I was reading the spreadsheet 2 nights ago, and I must say I was in awe upon seeing that you've written 25 opposed application judgments,
That's correct, JP.
2 urgent applications, judgment on 2 urgent applications,
That's correct, JP.
12 civil trials,
Correct, JP.
6 criminal trials,
Correct, JP.
9 criminal appeals,
Correct, JP.
3 civil appeals,
Correct, JP.
1 criminal review.
Correct, JP.
And as I understand it, you are more steeped in civil work as a magistrate than otherwise.
That's correct, JP.
Do you implement any case flow management in the magistrate's court?
Yes, we do, JP.
In 2 or 3 sentences, what is your understanding of judicial case flow management?
Well, JP, the judicial case flow management is intended, among others, to track the pace of the cases. It is to try and find out whether there is also any issues that can be narrowed in the cases with the litigants, and to try and see as to how can we reduce the delay of cases ultimately getting to trial.
Thank you, CJ.
Thank you, Judge President. MEC Gade, if you have any questions, I give you a chance to ask them.
Once more, thanks, CJ, and thanks to the panelists. Thanks for the opportunity. I just want to add one question to candidate CJ. Have you ever ruled against any piece of legislation and declare it as unconstitutional? If so, what was the matter at hand?
Thank you, MEC. I haven't had the opportunity to declare a piece of legislation invalid or inconsistent with the Constitution. I haven't yet dealt with that area.
Are you done?
That's okay.
Thank you. Commissioners, yes, Commissioner Dodovo.
Okay, thank you very much, ACJ. Thank you. Good morning, sir.
Good morning, Commissioner.
Okay. What is an interlocutory application and what are its benefits?
And what is?
An interlocutory application.
Yes.
And what are its benefits?
Well, an interlocutory application can arise when in a matter that is before court and that there is something a party has picked up in which he or she wants the court to deal with first. An example, an interlocutory application may arise where a party may apply to the court to strike out, where a party may apply to the court for an exception on a particular issue that had arisen in the matter. And so the interlocutory application has got a benefit that it can dispose of a matter which the court would have been seized with and burdened with, but through that interlocutory application, the matter then is disposed.
This application, applications applicable to the civil matters or criminal matters?
They are applicable in the civil litigation.
All right, thank you very much. Thank you, ACJ.
Thank you. Commissioner Tsepe.
Thank you, ACJ. Good morning.
Good morning, Commissioner.
There are some objections that that you have received.
Yes.
Some from the BLA.
Yes.
And some, I think, from the LSA.
Yes.
LSA.
Yes.
Would you like to address us on those complaints, just so we can hear your views on it?
Thank you, Commissioner. Upon reading the comments by the BLA, I gleaned that their concern is on two areas. One, it's in the area of having accepted a nomination from a particular advocate. I'm not sure whether I should mention the advocate. Should I mention the advocate? I don't have to. Now, BLA's concern was that it appears to them that this candidate, this advocate, has been harsh or has espoused views against a certain political organization. And the BLA, therefore, is suggesting that I should probably have turned down that nomination, or alternatively had asked the nominee to change his tone. My view on the matter is, fortunately, this advocate had attached the judgment concerned, and the judgment concerned, which I penned down, does not pronounce anything on the views expressed by the nominee. The judgment is very clear that it was focusing on the actors, and the actors in that matter was the plaintiff, whose complaint is that he was unlawfully arrested and detained. And my other concern, which is the actor in the matter, is whether the police have acted lawfully. Now, I had no interest in examining whether there's collusion between the IEC and the ANC, which is expressed or which seemingly is concerning the BLA in the nomination letter. Now, Commissioner, I do want to say that it is difficult to argue with someone on his or her views and opinions he or she holds, which has got nothing to do with me. And in this particular instance, I've got nothing to do with my judgment. And so that's how I can respond to that concern. I know the BLA has even suggested that I should apologize to this commission for having accepted that kind of nomination. I think that's too harsh. Let me address the second concern. The second concern is that the BLA seems to have committed an error, and that I say with respect, in that they've miscalculated my acting period and suggest that I've not acted enough. And as a result, much as I have a potential, their view is that I need to act more stints. Now, I don't think the BLA has taken into account a certain period which I've acted, that is 2019, where I've acted for 4 full terms in the Eastern Cape Division. That on its own, I think, would qualify me. And furthermore, I believe that my mere shortlisting suggests that I had met the requirements. So those are the two concerns that I find in the BLA's comment, unless there's another one. And quickly to the LSSA one. Now, the LSSA one relies on a matter of Manqina. Well, they have raised 2 areas. One is the case of Manqina, which was overturned on appeal, and the other issue they have raised is their concern in a matter in which I have not ordered costs at magistrates court scale. Now, I'll start with the Manqina matter. I must say, Commissioner, rightly or wrongly, probably I was very adventurous in the Manqina matter. Because in the Manqina matter, notwithstanding the provisions of Section 17(6) of the Road Accident Fund, I looked at it in a more progressive way to say that really could the legislature have intended that a person of straw like a mother in Mthatha, who does not have the money to spend for her child who needed a special school, and she doesn't have that money to spend, is she precluded? And I'm saying that probably I was adventurous because the appeal court had turned me down, which I accept. Now, that matter was decided on my second stint in the Eastern Cape Division. It was early in 2019 when I had my second stint. And if the concern is that in light of that case, I need more acting stints, I think, Commissioner, the events must have render that suggestion now a bit late, in the sense that since that matter, I've had another long acting stint in the Eastern Cape Division and in the North Gauteng High Court. So I've learnt from that case and I've been exposed even further. Now, the last issue the LSSA has raised is the issue of costs. Now, in the Van der Westhuizen matter versus Rigas, I didn't order costs at the magistrates court scale. Well, of course, it's at the backdrop that costs is at the discretion of the judicial officer. I did not, even though the award I gave to the plaintiff is 60,000. I did not. The reason is that that matter to me had serious undertones. And the undertones that I identified in that matter, which I have not in so many words raised in my judgment, is that that matter has a racial undertone. If you read that matter, you will find that the defendant says to the plaintiff, don't drive like this in Beacon Bay. Go and drive like that in Duncan Village, where there are people of your color at Duncan Village, because I have love for the children of Beacon Bay. Now, which I've raised in the judgment, my question was, if he's got love for the children, why would the children of Duncan Village, why would they be exposed to negligent drivers, right? And therefore, I did not order costs at the magistrate's court scale because of what I regarded in that matter as that I wish the defendant to understand the import of his attitude. I didn't. The Mbilini matter, which they are referring to, that which they are saying that, look, the judge may have been correct, is that in that matter, which was concerning Paia, much as I ruled in favor of the state institution, the organ of state, which was government, the manner in which that case was litigated and the tardiness with which the government handled the matter, I felt that despite having won the matter against the civilian, and not having ordered cost de bonis propriis against the attorney, I rather would order costs that each party pay his own costs. Now, that matter if you had read it, you would have seen that the application for information was sent to the National Office of SOCDEV, Social Development. The National Department did not immediately return or send it back to say that, no, you are knocking at the wrong door. You should knock at the Eastern Cape Social Development. So there was tardiness to a point that the process went as far as the applicants now making an appeal in terms of PAIA. It's only then that the national office became alert and aware. And they said, no, we have transferred the matter to the Eastern Cape Social Development. Now, I'm saying, when it comes to costs, that look, much as SOCDEV has won, because I found that, look, the information that they had supplied should be sufficient. I then felt that I will order each party to pay its own costs rather than mulct the civilian. Those are my responses to LSA as well as the PLA Commissioner.
Thank you so much, Mr. Nqumse. Thank you, ACT.
Thank you. I have Commissioner Madonsela and Commissioner Mpofu, and unless somebody feels strongly, would be reluctant to take somebody else except for the ones on the virtual platform. But if somebody feels strongly, they'll indicate to me. Okay, Commissioner Madonsela.
Thank you, Acting Chief Justice. Good morning, Mr. Nqumse.
Good morning, Commissioner.
You did the right thing to go and attend Bethel College in 1982. That's my alma mater.
Oh, I didn't know. Thank you.
Can a magistrate declare a statute unconstitutional?
No, Commissioner.
Thank you.
Commissioner Mpofu.
Thank you. Good morning, Clarence.
Good morning, sir. Good morning, Commissioner.
Yes, mine is a very short one, but I just wanted to tell the DCJ that place that the person said they must go and drive recklessly in Duncan Village, that's my birthplace.
Is it? I didn't know. There are so many coincidences here that I'm hearing.
Yes, no, I just wanted to, I see that you, like other applicants, have indicated that you would, you are applying for either Mthatha or Grahamstown.
Yes, Commissioner.
Or Makanda, actually. There's no
Yes,
such place as
it's Grahamstown, yes.
Do you have, just as a matter of interest, would you have any preference? If you qualified for either place, would you have any specific interest? And I say that for a particular reason. That reason is that, and I might be right or wrong, my view is that we probably need more black judges in places such as Grahamstown and Gqeberha, Makanda and Gqeberha.
Yeah.
So can you answer that question in that context?
To be honest with you, Commissioner, I didn't have a particular preference, and the simple reason is that in my earlier days on the bench, I've worked, I would say, as Lalin. As the SCJ was reading, I worked in Nqumse, Pedi, so I worked with Omama with big dukes. Queenstown is a semi-rural place which incorporates a lot of villages and ilalis, so I don't have a problem to be in Mthatha, which some people would not probably prefer. Neither would I have a problem to be at Grahamstown, any one of them. Well, Grahamstown would be, of course, advantageous in terms of distance for me, but I don't have a specific reason. I don't.
Thank you. Thank you, Chair.
Thank you. Commissioners on the virtual platform, is there anybody with a question there?
Thank you, CJ. It's Jenny Kane speaking.
Yes.
Good morning.
Good morning.
I would like to just assist you in one regard. We only need one letter of nomination, and I understand you have a letter of nomination for both courts from Nodell. And so even if there were a problem with the other individual, which I think you adequately addressed,
Yeah.
it would be fine. But I just also, for the sake of good order, wanted you to very briefly cover the objection raised by Mr. Steyn, where he says that you were presiding in matters where the attorney for one of the parties was a woman with whom you'd had a child and were living with. If you could deal with that very briefly.
Thank you, Commissioner. Well, Commissioner, what is troubling in Mr. Steyn's matter is the misrepresentation of facts, in the sense that I never presided in a matter where the specific attorney was a litigant. Even the matter that he apparently seems to be concerned and complaining about, though I do not know what interest he has, there has never been, one, a recusal for me in that matter. Two, the issue he is raising was non-existent at the time, and it's only after I had delivered judgment in the matter, a couple of months later, was I approached in chambers by someone who seemed to have an interest in the matter and said, if the plaintiff does not abandon judgment, he will see to it that he launches an application that would mortify me in the High Court, which unfortunately I had to give him a go-ahead to do so, than for me, functus officio as I was, to get involved in the matter. So I do not know Mr. Steyn as to his interest, nor do I know, because even his objection, it is my view, Commissioner, it's bereft of any material evidence. And if there was, it is my belief he would have much earlier had come out and had either laid a complaint or either been part of the review application or either assisted applicant with whatever kind of information he had at the time. So that is my response.
Well, thank you. That deals with the issue.
Thank you, Commissioner.
Thank you very much. I think we have come to the end of this interview. Thank you very much.
ACJ, sorry, I'm not sure whether you can see my hand or not.
No, I can't see it. You have one question?
I have a follow-up and then I have a question, ACJ.
Can you try and deal with either the follow-up or give up the follow-up or do the question rather than both? Is that something you can do?
ACJ, I would ask for your indulgence. I don't waste the Commission's time on
Okay, all right. Go ahead, follow up and the question.
The follow-up is very short. Good day, Mr. Nqumse. The follow-up is just on the Van der Westhuizen matter. The LSA also mentions that in that judgment, when you write the judgment, you nowhere mention what amount of damages was claimed.
Right.
So the question is just your comment on that, and then I'll move on to the question.
Well, Commissioner, probably that's a justified comment that in that matter I have realized that I did not mention the claim amount, which unfortunately was an omission, because in other matters which I've dealt with, I had mentioned the claim amount of the plaintiff. So I wouldn't take that matter any further, really, to argue against it, no.
Thank you. Now, on that matter of impreciseness, I want to draw your attention to an appeal that you granted where there was an incorrect order granted. I don't know if you can remember the matter. It was in the Minister of Police versus Duplessis.
Yes.
In the bundle on page 89, and subsequently there was an amended order. So if we can just look at that quickly, or I'll just take you to very quickly the appeal lies against the whole of the judgment of the magistrate for a finding that the arrest was unlawful, as well as the fiction that followed thereafter.
Yes.
And then when you make the order is made, it says the appeal is dismissed with costs on a party and party scale. And then on the next page, 110 is then the amended order. So the first part of my question is if you can take the court through how it came about that such a wrong order was made. And then after that, even when you rectified, if one looks on page 111, I want to put it to you that once again the order is lacking, even in its amended form, because it says then, I am therefore satisfied that detention was lawful and the appeal ought to succeed. And then you say the appeal is upheld with costs. The problem with the appeal is upheld with costs is one doesn't know what relief is being granted. I put it to you that it should at least have said that the claim is dismissed or something else, some other substantive relief in line with the fact that the appeal is upheld. So it's a two parts to the question. The first thing is how did the initial error come about? And your comment on the fact that the order still is lacking in some regard. Thank you.
Well, Commissioner, look, I must say that when I was pointed to the error, I wanted to beat myself in the sense that I go through my drafts a couple of times and I would send them back to the registrar or my clerk a number of times. And it was so strange that even the second judge whom I was sitting with did not spot that I've made an error in as far as the order. I can probably only ascribe this to the pressure of work that I had in the North Gauteng High Court. I must say I had a short time there and I wanted to produce many judgments. I normally say I used to sleep at 1 o'clock and wake up at 4 o'clock. And when I get to chambers in the morning, I have a Bible of manuscripts for the secretary who I could see now she's overburdened. So I think it was just a slip on my part. And this slip, strangely, even happened with my sister with whom I was seated, that we did not see that the order at the end is not what we were purporting it to be. So that's my explanation on that. And of course, we sought to rectify the order, as you are pointing out. I did not find that there is something lacking in the order. I did not find that. But I guess it's something that I need to apply my mind to as you are raising it. I did not find that there is something that was incorrect with our order.
You're done, Commissioner Barnard.
Thank you. I just want to make sure. So the candidate is then indicating that you are happy with the order in its form there. It shouldn't say that the claim should be dismissed or the claim is dismissed with cost. The appeal is upheld and the claim is dismissed with cost.
I have no qualms with that, Commissioner. I have no qualms with that.
With your indulgence, ACJ, is the order lacking in that sense? Would you at least concede that?
Commissioner Barnard, the order that you are talking about, is it the amended order or the earlier one?
The amended order on page 111 of the bundle, ACJ.
Must he amend it? Must he amend?
Well, the amended order says that the appeal is upheld with cause. But Mr. Nqumse, you want to comment on that? I think Commissioner Barnard wants to be sure whether you are saying you think that the amended order is fine, or whether you think it is lacking, it should have said something else, or should have added something else.
Well, SCJ,
The claim is dismissed. The appeal is upheld and the claim is dismissed with cause. So that's the question, just to assist the ACJ on that.
which claim, I'm sorry, ACJ, may I just ask for clarity's sake, which claim are we talking about now?
Thank you. If one looks at the appeal is against a matter where a claim was, or it was held that there was an unlawful arrest.
Yes.
So if the appeal is upheld, should it not then say that the claim is dismissed?
No, well,
okay, maybe let me try and understand, Mr. Nqumse.
Yes, ACJ.
In the magistrate's court,
Yes.
Mr. du Plessis had instituted a claim against the Minister of Police. Is that right?
Correct, ACJ.
And the outcome thereof was in favor of Mr. du Plessis. Is that right?
Correct, ACJ.
And the detention was found to have been unlawful by the magistrate.
Correct, ACJ.
And the Minister of Police appealed.
Correct, ACJ.
And the Minister of Police, in his appeal, wanted the decision of the magistrate's court to be set aside.
Correct.
And that the detention be held to have been lawful.
Correct, ACJ.
And you concluded that the detention was lawful.
Correct, ACJ.
And you then upheld the appeal.
Correct, ACJ.
Okay, and you upheld the appeal, but you did not set aside the order of the magistrate, isn't it?
Correct, ACJ. Let me just...
Should you have set it aside or should you not have set it aside? I think Commissioner Barnard's question may be directed at that.
All right.
To say, if you uphold the appeal, do you stop there, or do you go ahead, continue, and then do something else?
Just, I'm sorry to waste your time, CJ. I just wanted to check the preceding paragraph. I just want to check the preceding paragraph from the original order. I just wanted to check something, but I don't see it now. ACJ, I won't make bones about this. If the reading of the order as it stands, if reading of the order as it stands, someone would still be in doubt about the claim of the plaintiff, which was upheld by the magistrate, and that I should have been specific to mention that that claim has been dismissed. Once again, I would not have a problem to say it's something one could add, but I wouldn't necessarily say that the order is deficient as it stands. I stand to be corrected.
No, Mr. Nqumse. If it's an appeal, you can't just say the appeal is upheld and stop there, at least in this context.
Okay.
If the lower court made an order that it should not have made,
yes.
In other words, made a wrong order,
right,
and the losing party appeals,
yes,
then on appeal, you say you uphold the appeal,
yes,
and you set aside the order of the Kotako, and replace it with the order that the Kotako ought to have made.
Correct.
So if you conclude that the magistrate's court should have dismissed Mr. du Plessis' claim,
yes,
then on appeal you set aside the order of that was made by the magistrate's court, which you regard as wrong, and then you say in the place of that order, or you replace that order with an order that says the claim is dismissed with cause. That is what you would do.
I take that advice, ACJ.
Yes.
I take
But I
that.
see that actually
That's,
at paragraph 107,
Yes,
paragraph 55,
yes,
yes.
you actually say, I'm therefore satisfied that the detention was lawful, which means the minister succeeds.
Yeah.
yes.
And the appeal ought to be
That's
dismissed.
that's where the error is, ACJ.
Yes,
That's where the
you have
error
said the
is.
appeal is
Yes,
upheld.
yes. That's where the error
Yes,
is.
yes. Okay,
Yes.
all right. Okay.
Yes.
I think, yeah.
No, it's
Okay,
fine.
okay, I think we are done. Thank you very much, Mr. Nqumse.
Thank you very much, ACJ, for the opportunity, and I thank the commissioners.
Thank you very much. You are excused.
Thank you very much.
Okay.